Hello friends, in the series on the income tax cases, today we will discuss a very important case on the allowability to a charitable organization of section 11 exemption. It has been generally seen that when the assessment proceedings are going on, the assessing authority try their level best to prove that the activities of the assessee are in the nature of business and the activities of the assessee fall in the last category of charitable activities, that is advancement of any other object of general public utility. This issue has been taken up by Bangalore ITAT in the case of Navodaya Grama Vikas Charitable Trust versus Deputy Commissioner of Income Tax, and this case is reported in 120 ITR Tribunal at page number 655. The date of the judgment is 31st August 2023. In the present case, the assessee was a charitable organization. The assessee object was to provide relief to the poor to help them avail of the benefits of insurance and microfinance. From the facts of the case, it was very clear that these microfinance was provided to the various poor families on a very marginal rate of interest, and these microfinance was provided without taking any security from them. When the assessment proceedings were going on, the learned assessing officer was of the view that providing loan to the various poor families comes into the definition of business activity, and since the assessee comes under the last limb of the charitable activity according to section 2 clause 15, that is advancement of any other object of general public utility, so the benefit of section 11 should not be given to the assessee. So he accordingly denied the benefit of section 11 to the assessee. When this matter was heard by the tribunal said that according to section 2 clause 15, the charitable purpose includes relief to the poor, education, medical relief to the poor, advancement of any other object of general public utility, and preservation of monuments, etc. Since in the present case, the benefit of section 11 has been given to the assessee in the last years also, and there is no change in the facts of the assessee, so the benefit of section 11 cannot be denied on the basis of the consistency also. The tribunal said that in the present case, there was no personal benefit of the trustees. The assessing officer has grossly failed to prove that the assessee is not doing any charitable activity. The assessing officer is not able to prove that the assessee is charging exorbitant rate of interest. The assessing officer has failed to prove that the interest charged by the assessee is not commensurate with the cost of the assessee. The tribunal said that in the present case, the assessee has to incur the various expenses like insurance and other administrative expenses to do its charitable activities. So, charging of marginal rate of interest, that is very less than the market rate of interest, and that is without security. In that circumstances, it cannot be said that the assessee is doing any business activity. The tribunal said that in the present case, there is no denying the fact that the activities of the assessee are charitable activities, and the activity of the assessee falls in the category of advancement of any other object of general public utility, but there is no evidence and there is no fact which prove that the assessee is doing any business activity, because whatever the interest is being charged, that is very less than the market rate of interest, and on the basis of consistency also, the assessee could not be denied the benefit of section 11. At the end of this video, once again I am repeating the name of the case. The name of the case is Navodaya Grama Vikas Charitable Trust versus Deputy Commissioner of Income Tax, and this case is reported in 120 ITR Tribunal at page number 655. The date of the judgment is 31st August 2023 and the matter has been decided by Bangalore Tribunal. Thank you, friends.